Well, hello, everyone. I'm Lisa Foster. I am the co-executive director of Fines and Fees Justice Center. And with me today are Priya Sarathy Jones, FFJC's deputy executive director, Tim Curry, FFJC's research director and amicus counsel, and Jeff Selbin, professor at Berkeley Law and the co-director of the Policy Advocacy Clinic at Berkeley. As many of you know, in March of 2016, the Department of Justice issued what came to be known as the Dear Colleague letter. It was a letter sent to every state chief justice and state court administrator, and it discussed certain constitutional and statutory provisions that DOJ believed applied to the enforcement and imposition of fines and fees. The letter was signed by me. I was then the director of the Office for Access to Justice at DOJ, and Vanita Gupta, who was then the head of the Civil Rights Division and is now the Associate Attorney General, the number 3 person in the Justice Department. Shortly after Jeff Sessions became the Attorney General in the Trump administration, he revoked the letter. And let me add, in addition to the Dear Colleague letter, there was also a juvenile advisory that went out from the Office of Justice Programs and from the Office for Access to Justice, and that too was revoked by Jeff Sessions. This past April, the department issued a revised Dear Colleague letter. It discusses relevant case law, much of it new since the original Dear Colleague letter. The letter cautions against the discriminatory enforcement of fines and fees, details the obligations of jurisdictions that receive federal funding regarding the imposition and enforcement of fines and fees, and it makes thinly veiled threats to take action against jurisdictions that don't comply with those obligations. The revised Dear Colleague letter is long, and it is written in DOJ speak, a language which, for better or worse, the 4 of us speak comfortably. Our goal today is to help you find and understand the key points in the Dear Colleague letter, and more importantly, to think strategically about how you can use the letter in your advocacy, including how you might be able to take DOJ up on its threat to enforce the Constitution and various federal statutes. We're not going to go through the entire letter, just what we think are the most salient points. To help, we're going to put a document in the chat that we've created for you. It's called Decoding DOJ's Dear Colleague letter, Key Points for Advocates. And we'll also email that document to all of the people participating today. And we will also email any other documents that we reference during the webinar. We're also going to talk briefly today about what else DOJ has planned with respect to fines and fees, and provide a lot of time to answer questions. In that regard, there is a Q&A button on the bottom of your screen. You can put any questions that you have in there, and we will be able to see them a little later on in the webinar. With that, I'm going to turn it over to Priya.
Thanks, Lisa. I really want to lift up, so we think about this letter in terms of how we can be using it to advance our advocacy goals, our legislative goals that I know I work with a lot of you and our team does around the country to think about where can we move this issue of fines and fees. This document really is what I would consider the constitutional floor for where fines and fees reform should go, right? This is the bare minimum that people should be doing in terms of their legal requirements as governments and practitioners of law. Obviously, that is not what our goals are as advocates, right? Our goals as advocates are to design and implement a system that truly is supporting justice, that is really living up to something much bigger than our constitutional floor. And so some of the things that are in this letter really do support that, because there are some really great talking points and sort of general phrasings of things that really coming from an institution like the Department of Justice mean a great deal more sometimes than when they come from an organization that's whole mission is to advocate for fines and fees reform across the country. So looking through, and Lisa and the organization put a lot of these general talking points to lift up, but This first one of eliminating the unjust imposition of fines and fees is one of the most expeditious ways for jurisdictions to support the success of youth and low-income individuals, honor constitutional and statutory obligations, and reduce racial disparities in the administrative justice and ensure greater justice for all. This is a really guiding principle, right, of what it means to do fines and fees work, and what the core of our advocacy really is to, and also how we prioritize the work of fines and fees reform in this much larger legislative agenda that is criminal justice, economic justice, racial justice work. And so also that courts and prosecutors and police should be driven by this justice and not by revenue, which is another fundamental point to fines and fees reform when we're thinking about it. We all know when we are doing this work, it is so revenue driven that even after we get some of the ideological buy-in on this is wrong, this is where the harms are, the questions that remain at the end of the day are oftentimes about revenue and about money. And so really having something coming from the department in our use of advocacy that cannot be a supporting factor of why we are continuing to have these policies in place. It can't be that we don't know how to fund something else, or we don't know how to support it financially, or where will our money come from? So really, really lifting that up in our advocacy. And thinking about this last part, that failure to comply with the constitutional legal requirements, so that fundamental baseline we were talking about, it might expose jurisdictions to civil enforcement actions by the department. And we'll talk a little bit more about how that comes to be later, but this last piece, you know, we like to think about our carrots and our sticks, but right, having something where we're able to say in our advocacy that this is the baseline. And unfortunately, the baseline isn't even something many places are adhering to in fines and fees reform. But when they're not doing this, what are our avenues to get the kind of policies we want, which is when the department is looking and willing to investigate and willing to really examine what these policies look like and use their enforcement mechanisms to, in the way I look at it, advance our advocacy goals, which is something that Jeff will be able to speak to, how this actually comes together in practice, right? We're advancing policies, ideas, principles through our fines and fees reform, but sometimes they need a little nudge. And sometimes we need to use some of our other levers to get people to buy into why these things have to happen beyond just it is the legal requirement that we do so. And so how those two things work in partnership, and Jeff being able to give us a little more insight in how we've done that in the past as has happened, and how it has led to really, really meaningful reforms in California as one of our leading states in fines and fees reforms across the country. So I'm going to pass it back to Lisa, who's going to, and Tim, who will be able to walk us through a little more detail section by section on the most relevant parts of this.
I'll take it, Priya. So we're going to start off with looking at some of these constitutional principles so we have a better understanding of how to leverage them. And the first one I want to talk about is this 14th Amendment due process requirement that you really can't punish someone for non-payment without assessing their ability to pay. And so this grows out of a series of cases in the 70s and 80s that the Supreme Court ruled on, ending with one called Bearden v. Georgia. And basically what the court has said is you cannot, the question is not whether or not the fine or fee was paid, it's whether the person willfully did not pay. Did they have the ability to pay and chose not to? And the court has as the Department of Justice points out in this letter, has affirmative obligation to figure that out. So it's on the court, whether we raise it or not as defense, to know whether the person had the ability to pay before imposing severe sanctions. Now, Bearden and its other related cases, Tate and Williams, they all looked at this in the situation of incarceration, but the letter, the DOJ letters, is very clear that the spirit of this constitutional principle is any severe restriction on liberty. And so they extend it to things like driver's license suspensions, increased probation requirements such as extra reporting or increased drug testing, not related to actually getting things paid. And so this idea that you can't be lumping on all these restrictions to force someone to pay if they don't have that ability. The other kind of thing that came out of Bearden was this idea that if you're not short of incarcerating, there are other things that courts can do, and they should be looking creatively at how they can advance the state's goals without locking someone up or severely restricting their liberty. for non-payment. And so they talk, the letter really outlines it better than I think some of the cases do. Jurisdictions can use payment plans as long as those payment plans don't include extra fees, to be honest, because we're not supposed to be compounding this debt. Connecting people with programs that help build workplace skills and actually get them on the track to having better employment to pay off these debts. How about just reducing or waiving any debt that's unlikely to get paid? Why are we saddling and creating these burdens? This is a tool that courts have. They can waive in many instances or reduce these costs. Classes or community service as alternatives to a financial payment. But the DOJ letter is also very good. And you know, it's lawyer speak, it's DOJ speak. So sometimes it looks like they're talking out of both sides of their mouth. And so it's on us to kind of cut through that and say, well, what the spirit of this letter is saying is that, hey, you can't be imposing any of these other solutions if they're creating other disparities. And so think about community service. If one person can pay a $100 fine and be done with it, another person has to do 20 hours of community service in lieu of $100, that's probably going to create economic and racial disparities in your system. And so you should be very mindful about how you're pointing that. So that's just a broad overview of why you can't severely punish for non-payment. Now I'm going to turn it over to Lisa to talk about the excessive fine clause and how that also plays into it.
And before I do, I just want to say now, I hope, and I apologize for the earlier glitch, be able to access the document. And if not, please let us know. Okay, so the second constitutional issue we're going to talk about is the excessive fines clause. It's found in the 8th Amendment to the US Constitution and in many, but not all, state constitutions. And it says simply, excessive fines shall not be imposed. That's it. The discussion in the revised letter is new. It was not it's new because called Timms versus Indiana, which many of you know about. And in the Timms case, the US Supreme Court answered a very simple question. Does the US constitutional provision about excessive fines apply to all of the states, whether there's a state excessive fines clause or not? And the answer was unequivocally yes. But what they didn't decide, although they made a lot of hints about how they would decide, is how does a court determine what's excessive? On that question, though, the Dear Colleague letter actually, although it doesn't specifically say this is what the Constitution requires, they're pretty clear that they wholeheartedly endorse a particular standard. And that's the standard that the Indiana Supreme Court imposed when the Timms case went back down to the Indiana Supreme Court. And it's a standard the Washington State Supreme Court adopted in a recent case. And that standard is essentially a fine is excessive unless it's proportionate both to the offense and to an individual's financial circumstances. In other words, what might be an excessive fine for a minimum wage worker is not necessarily an excessive fine for me. And what's an excessive fine for me is not what might be an excessive fine for a gazillionaire like Jeff Bezos. And that is particularly important. And the Dear Colleague letter affirmatively or approvingly quotes from the Washington State Supreme Court. And they said, and I'm quoting, considering ability to pay is constitutionally required. I'm going to come back in a moment to talk about ability to pay determinations, because the Dear Colleague letter has a lot to say about how those are to be done. But I want to just talk briefly about how you can use the excessive fines clause in advocacy. And the first is, obviously, if you're thinking about legislation that would allow courts to waive or reduce fines and fees, then you can be referencing the excessive fines clause to say, you have to do that determination at sentencing, or you're going to run afoul of the excessive fines clause. You can't do it at enforcement. And if you're doing it at enforcement, it's too late because you've already imposed what might be an excessive fine. And you can similarly argue that there have to be sliding scales for certain for fines or for certain fees, like, for example, towing and impound fees at the local level. So that's, in our view, how this can help move courts themselves, but also legislative advocacy around ability to pay. So I'm going to turn it back to Tim to talk about conflicts of interest and the right to counsel.
So the new letter has an entire subsection specific to conflicts of interest. And so it's a really interesting kind of way that we can think about some of these constitutional conflicts. Conflict of interest comes out of, again, the 14th Amendment due process clause. And basically it bars any system where the fact finder or is not a neutral person in the scenario under this. So it bars conflicts where the institutional financial interest, the institution has a financial interest in the outcome of the case or the scenario. And so basically what we're looking at is there's a lot of new case law out of the Fifth Circuit, and this is what the DOJ is leveraging in this section. So there's two cases, Kane v. White and Caliste v. Cottrell, and they look at this idea that what constitutes that gain. Does it have to be financial? Does it have to be pecuniary? And these cases have extended the constitutional assessment of neutrality beyond just profiting from it. So when judges or fact finders benefit in some way, directly or slightly indirectly, then this conflict can arise. And so these scenarios that we saw are the judge may not get money, but the funds are being used to pay court staff or computer systems that make the court run more smoothly. And the courts have found that it all comes down to a question of remoteness. How remote is the benefit from the fine or fee coming in? And when the court finds that it's not that far off, that the judge's life is improving because of the money coming in, then we might have a conflict of interest. And so this case law is somewhat relatively new, and so this is a good place for us to be pushing that, both in our litigation, but also in our advocacy. We can start pointing it out now to lawmakers who are creating these systems. Well, look, you might be opening yourself up to litigation or investigation from the Department of Justice if you're creating even these non-financial conflicts. And it's not limited to judges. I think that's the other important point that the letter points out, is that this neutrality requirement is on any law enforcement, probation, other actors of the justice system who should be neutral and who may have some kind of benefit conflict from the fines or fees that they're responsible for enforcing. And so this is ripe for a lot of new advocacy on our part. And the last constitutional principle that I'm going to talk about is the right to counsel. And where the right to counsel exists under the Sixth Amendment, being able to pay for it not being able to pay for it cannot deny you the right to counsel. It's a basic Fuller v. Oregon argument. But again, the Department of Justice is doing citing a lot of case law, putting the dots down in the letter without necessarily connecting them for us. And so one of the things that I found really interesting is they talk a lot about the right to counsel, and then they have a brief discussion about Alabama v. Shelton, which is 2002 case, where the court said, you can't incarcerate someone later if they didn't have counsel up front in a criminal matter. And so thinking about how that plays out, that was a misdemeanor case. They couldn't revoke that person's probation because he didn't have counsel at the misdemeanor initial stage before conviction. I'm going to use the traffic example. I think is a great one where we as advocates can push this. So 14 states still criminalize traffic. Speeding or rolling through a stop sign is technically a misdemeanor. And in a state like Texas, though it's a crime, lots of the jurisdictions do not provide a right to counsel under the theory that it's a fine-only offense, and therefore there's no incarceration on the table, and so you don't need a lawyer. But some of those we know anecdotally, some of those same jurisdictions are still locking people up for non-payment. That is the exact same thing that's happening in Alabama v. Shelton. You didn't have a lawyer up front, you didn't comply with your sentence. In this case, it was a purely financial sentence, and now they're trying to incarcerate you. The DOJ is giving us all the tools there to say that's unconstitutional. and that we shouldn't stand for those kinds of the other interesting thing about counsel that the Department of Justice puts in the letter is raising this issue of a civil right to counsel. We don't have a constitutional civil right to counsel in all areas, but they talk about a case in Turner where a parent was being jailed for non-payment of child support in the civil context. And the court said, well, yeah, there may not be a civil right to counsel in that context, but if you're not going to provide a right to counsel, you have an absolute due process right to ensure that that unjust incarceration doesn't occur. And what does that require? It requires adequate notice of everything that the person is accused of and what might happen to them if they don't comply. It is about giving enough notice about what the standards of evaluation will be, in this case, ability to pay, and so that they have the ability to present their own defense in a meaningful way to prevent their own incarceration, and that the court actually has to consider those things. And so that's in a civil context. We'll think about it again in those, we have lots of places around the country where courts are trying to use civil contempt as a way to enforce non-payment of fines and fees and locking people up on civil contempt. This, again, is one of those areas where this tracks. We should be looking at those constitutional principles of due process, not necessarily rights to counsel, but if you don't have a right to counsel, then you have a due process right to all of these other protections before you're locked up. And being able to leverage that, whether it's through our legislative advocacy creating the systems or through other litigation. And now I'm going to turn it back to Lisa to talk a little bit more about ability to pay.
Ability to pay, and what do the departments say about it? Well, first they say, again, state and local courts, and I'm quoting, have an affirmative duty to determine an individual's ability to pay. And again, as Tim pointed out, sometimes the letter doesn't connect all the dots that they leave for us, but here is where they really are saying that to comply with the excessive fines clause, you have to do that at sentencing. So the second thing they say is that ability to pay determination will be made even if a defendant does not specifically raise the issue. In other words, you can't have a rule that says the person who's being assessed fines and fees has to ask the court to do an ability to pay determination. The court's supposed to do it as a matter of course. And places where you have to make a motion or you have to actually say, Judge, I can't afford this, are out of compliance with the mandates the department's laying out. Third, they say that the focus of an ability to pay determination should only be on a person's income, not how they spend their money. Now, we've all heard horror stories about courts saying things like, oh, I see you have a cell phone, therefore you can afford to pay your fines and fees, or you have a nice pair of sneakers on, or whatever it is the court's making its determination based on. And the department's saying unequivocally, that's inappropriate. It's not for the court to decide how you spend your money, it's for the court to say, do you have enough money? And the third is that when you do an ability to pay determination, the courts have to apply, and these are the department's words, uniform and consistent standards. Again, you can't leave it up to each individual judge to decide for him or herself how they're going to determine someone's ability to pay. There have to be rules, and those rules have to be complied with. Finally, the department says jurisdictions should benefit from using presumptions about certain classes of people. So people eligible for public assistance, unhoused people, people who are serving a term of incarceration, people below a certain income level. And all those specific things are in the Dear Colleague letter. And again, we think that's an important thing for courts to be doing when they're figuring out ability to pay. And all of those points are obviously useful in advocacy, not just with courts, but also with legislatures, to the extent that there is ability to pay language either in existing law, but there are no standards, or if you're going to put ability to pay language in a law, making sure that there are standards. So now I'm going to shift gears a little bit and talk about the last kind of constitutional point that makes, and that's access to the courts and notice. And on notice, it really comes down to a simple proposition. The department very clearly says people have to get it, not you have to send something out, but you actually have to ensure that people get notice, and that it's, as Tim pointed out, notice about what's going to happen, how they have to comply, when there's going to be a hearing, and it has to actually reach them. On access to the courts, again, the department in this instance is unequivocal, and that is, they say you cannot condition a hearing or a trial or any other court procedure on money. That is, you can't charge a fee to get into court. But we know a lot of courts do that. And I'm going to give you an example of something that just happened where we were able to use this provision of the Dear Colleague letter. So in Nevada, they had a provision in state law that said, in order to challenge a traffic citation, you have to post a bond. And the amount of the bond is the full amount of the fines and fees that you would owe if the court found you guilty. So in other words, if the total fines and fees were $250, before you could challenge your ticket and argue that you weren't guilty, or it was a bad ticket, you had to put up $250. And there was some cleanup legislation in the Nevada state legislature. We were able to go to the sponsor and say, you know, the Department of Justice just says this provision is unconstitutional, and hand them the letter. She put in an amendment to the bill. There was some controversy from the courts in particular, and from law enforcement, who thought that that bond provision would, as of course it does, deter people from challenging their tickets. And they didn't, in the court's case, want to have more hearings. And in the cops' case, they didn't want to have to send cops to court. We wrote a short one-page memo, and we said, here's why the Nevada provision is unconstitutional. And we just quoted the provisions of the Dear Colleague letter. And the bill passed with the amendment. We're waiting on the governor's signature, but it's a clean and neat example of how in the moment, and we will send you a copy of that memo with the materials we sent in the webinar. So you can see just very cleanly how you can apply some of this to your work. Now I'm going to turn it back to Tim to talk about youth.
Yeah, the last thing I want to talk about is the specifics that apply to youth in the juvenile system. As Lisa mentioned, there had been a separate letter on the enforcement, constitutional enforcement of fines and fees practices against youth in juvenile proceedings in the Obama administration. Those two, that got lumped in this letter with the adults, but there are really some important parts to look at. Most predominantly is because the Department of Justice has a much clearer mandate for enforcing in the juvenile context. They have statutory authority to look at patterns and practices within the juvenile context. And so when these fines and fees issues come up, it's really important to look at them in that context. But I think one of the greatest lines from the letter is that jurisdictions should presume that children and youth are indigent and unable to pay fines and fees. It's a flat out presumption of two things: indigence and an inability to pay fines and fees. And I think that distinction, the and, is important. Indigence, often in DOJ speak, and the way that OJJDP looks at it, is the precursor to access to counsel. And so under the due process, so the youth have a 14th Amendment due process right to counsel. It's not a 6th Amendment right to counsel. And part of whether they should have counsel, if we were presuming all youth are indigent, then money is off the table. Automatic appointment of counsel becomes the standard. And that's then taking that indigence determination, that assumption that all children don't have the money to pay for their lawyers, and extending that to all other fines and fees. And the language that the Department of Justice uses is kind of very logical, but it's great, some of the language you might want to quote. Minors are generally unable to earn money. They are too young to legally work in some circumstances, are of compulsory school age or full-time students, therefore they can't work as much as an adult. They have great difficulty in obtaining employment due to having a juvenile or criminal record, or simply because they do not yet have employable skills as an adult. These are common sense things that we should be thinking about, why children in and of themselves don't have money. Now, we know in practice, a lot of courts around the country may impose that fine or fee on a parent. And the letter also addresses that this is creating a kind of a conflict, and it is contrary to the goals of the juvenile court system, which is rehabilitation. They flat out say that when it is imposed on a parent must face the untenable choice between paying court debt or paying the debt of entire family's unit's basic needs like food, clothing, and shelter. Now, as an aside, the Fines and Fees Justice Center just released a report called Debt Sentence, How Fines and Fees Affect Working Families. And it's the first national kind of survey on the impacts of fines and fees. And it shows that of those who have had fines and fees in the last 10 years, 35, and this is just adults, we're not talking about kids, but so if it's their parents, 35% faced food instability due to their court debt. 27% saw some housing concerns based on their fines and fees. So we have now data that backs up this what the Department of Justice is saying, that it's creating an untenable situation for entire family units if we're putting this money on children. So that's a good policy argument to go along with our constitutional arguments in this context.
And before I turn it over, sorry, Tim,
No,
before I turn it over to Priya, I think it's an important thing to emphasize, and the reason we quote the department both in the decoding document we provided you all and in the webinar is, you know, we can say things and legislators go, oh, yeah, you're a bunch of advocates. When the Department of Justice says it, it can have a bigger impact than when we say it. And so being able to use what they say can sometimes move legislators and policymakers. So Priya, I'm going to turn it back to you for provisions we have.
Yeah, and before we sort of get into the specifics of DOJ enforcement, and I'm Jeff and Lisa talk about how that avenue may be pursued, just letting you all know and reminding you that FFJC continues to be a resource in thinking through with all of you individually and uniquely for the circumstances you're sort of trying to achieve in your particular jurisdiction, how to use this letter effectively in your advocacy, right? And so Lisa gave mention to how we were able to use it in one of the states that we are working in Nevada, to really advance the legislation in the right way, so sort of deal with some of the provisions that would have been problematic based on this letter. We are also working with colleagues in other states and using this letter to be the basis for recommendations that are coming out of the legislature or for specific bills in the legislature that would then bring them into not only compliance, if you will, with the baseline standards of the law, but if we have the opportunity to address it, why not address it in the best policies with the best practices, right? And really also taking it well beyond what the letter says. So that is also part of thinking through the advocacy, is this might open the door in states to place to ideas and reform that they were initially reluctant to take on at all. And then when that door is open, we're obviously able to use a lot of the tactics and strategies that we've been using across the country to advocate for the best practices and policies we'd like to see that go above and beyond what that baseline standard is. And it's a little bit rare for us to see someone who says, like, I only want to do what the legal baseline is. So we want to, use that to our advantage of, hey, we know you're not in compliance with the standards in the law, which opens us up to litigation and to enforcement, into a lot of things that people and to spending money, right? So when we're talking about saving money and being more resourceful. So please reach out to us if you have really specific needs, if you're looking to advance some of this stuff in your legislative advocacy next year. We are happy to send Lisa. I like to use her a lot in this particular advocacy strategy, because she wore these two hats of being one of the original signatories on the original letter. And it holds a lot of weight to have someone who has that background speaking to some of the folks with that type of authority, and also how we use it in some of the work that we're doing on the ground. So please reach out. And if there are any tools we can develop that would make this easier for you, we're also happy to take that on and make something that's a little more universally usable. So we welcome your ideas and thoughts around this as we're thinking about how to leverage this letter in upcoming legislative sessions. So I'm going to kick it back over to Lisa and Jeff to talk a little bit about how to actually think through this DOJ enforcement opportunity, how it's worked in the past, and what this may look like.
Great, thank you, Priya. Lisa, you want me to go ahead and start?
Please.
Great. Well, first, thank you to the good people at the Fines and Fees Justice Center, for leading the national effort that yielded the Dear Colleague letter, but also for putting this webinar together and for including me. I'm really honored actually to be here with people whose influential work I've just admired for so long. So it's a treat. Lisa asked me to share our experience with a DOJ enforcement mechanism in the campaign to end juvenile fees in California. And I'll just note that it's actually included toward the end of the Dear Colleague letter itself in footnote 52, if you get that far, as an example of the DOJ's authority in this area. For some context, as Lisa said at the top, I co-direct the Policy Advocacy Clinic at Berkeley, which we started 10 years ago in conjunction with our community clinic, the East Bay Community Law Center. One of the earliest problems identified by EBCLC was that local families with youth in the juvenile delinquency system were showing up with bills from the county for thousands of dollars in administrative fees. And they were being charged for things that likely everyone on this call is familiar with: their kids' detention, drug testing, supervision, electronic monitoring, and as we've talked about, even their constitutionally guaranteed lawyer. And the fees, as I said, added up to thousands of dollars per family. I won't share all the details, but over the next few years, our students conducted a bunch of interviews, research, data collection, et cetera, to support advocacy campaigns to end juvenile fees, first in Alameda County and then in other Bay Area counties. The hope was that the local reforms would both establish that total fee abolition was possible and lighten the lift for statewide repeal in Sacramento. In late 2015, while we were in the thick of the Alameda County campaign, Karen Lash in Lisa's Access to Justice office at the DOJ, I don't know if Karen is on this call, hi if you are, she shared information with us about an upcoming White House convening that included a piece on fines and fees. We were quickly in touch with Karen and Lisa, who were eager to learn more about juvenile fees, which at least at that point had received less attention than money on the adult side in the system. Among the materials that we shared with them was the first fact sheet we put together for the Alameda County campaign, and it was a simple one-page document with two tables. First, it had a list of juvenile fee burdens in the 14 most populous counties in California. And second, it had a scale showing stark racial disparities in fee practices. Alameda County was a bad actor on both counts, which is why we put the fact sheet together the way we did. But Sacramento County was actually at the top of the list because at the time it charged the highest fees in the state. Our Access to Justice friends in the department shared these materials, I think, internally with their colleagues in the Office of Civil Rights. And I wasn't aware of this at the time, and you may not be aware of it, but OCR is responsible for ensuring that recipients of financial assistance from the department comply with federal civil rights laws that, among other things, prohibit discrimination against people on the basis of race. Significantly, and Lisa may have more to say about this, unlawful practices in this context don't require a showing of intentional discrimination. I think this is really important. It's enough to show that the county's practices have discriminatory effect. Sacramento County, like almost every county in the country, maybe every county in the country, receives federal assistance subject to these civil rights laws. So OCR has jurisdiction to investigate these practices. And I want to say that Tim is right that they've got some special authority statutory authority with respect to youth, but that's not what was at play here. This was just their general authority to investigate discriminatory practices. In August 2016, after several conversations with OCR staff, we shared a trove of documents and data that we had gathered from Sacramento County through Public Records Act requests. Based on those documents and OCR's own research about their obligations, about the county's obligations as a recipient of funds under OCR's jurisdiction. And again, Lisa may want to say more about this. But by the end of 2016, DOJ had initiated a compliance review, essentially an audit of both a county and its superior court to examine whether their juvenile fee practices unlawfully discriminated against youth. The compliance review coincided with a number of California counties ending juvenile fees, again, first in the Bay Area, and a bill to end them statewide, but it clearly spurred the Sacramento County Board of Supervisors to voluntarily stop the practice in April 2017. Along with that, they forgave more than $23 million in outstanding fees, so it also helped set a precedent for the idea that you could discharge outstanding debt. As Lisa said, I think we're going to share all of these documents with participants in the webinar, but in response to the county's actions, OCR formally closed the review by letter the following month. And we can share the letter because I think it's instructive to kind of reverse engineer what the process looks like and what they're looking for in these kinds of reviews. Because again, we shared information, but I wasn't familiar with all of the statutory and regulatory obligations that the counties had. As Priya alluded to, the Sacramento fee repeal and debt relief turned out to be a major event in the California campaign. Sacramento County, which of course includes our state capital in Sacramento, became the first county outside the Bay Area to end juvenile fees. Not long afterward, the legislature passed the first bill in the country abolishing juvenile fees statewide. That has since been followed by 19 states that have ended most or all juvenile fees. I'm hoping that, again, Lisa will share more from her perspective, including key takeaways for everybody on the webinar. But as the new Dear Colleague letter clearly demonstrates, we once again have allies in the DOJ who are ready to work with us on this. We did not for 4 years, but we do again, and help us move forward the reform agenda. So I think I'll stop there and let Lisa jump in, and I'm happy to answer questions.
Well, let me just, before I emphasize a couple of points, just say that as is obvious from Jeff's presentation, he has been doing this work for a very long time. And the Debt-Free Justice Campaign nationally, which has been focused on fees in the juvenile justice system, has been amazingly successful and really done terrific work. The partner organizations, as well as many of the groups on the ground that they work with, impacted youth and their families. So we're grateful to have Jeff here with us today. Let me just emphasize a couple of points. The department says in the letter unequivocally that they have the ultimate sanction, which is to take away the money that they have given to state and local jurisdictions if they find that they don't cooperate with their investigations and refuse to come into compliance. So just as background, federal government obviously has lots of money it gives to the states, and the Department of Justice in particular has one huge source of funding. It goes out to every state in what's called a formula grant. So it goes based on your population and a whole bunch of other factors. Every state gets this money, and it has to be used in the criminal legal system. How a particular state spends its money is really up to the state with some guidance from the Department of Justice. Most states have a state advisory council, board, whatever they may call it, different things in different states. But and in some states, it's simply a pass-through. They just send the money down to the counties, and the counties have that kind of a board. That's the case in a big state like California. What we have learned from the Office of Civil Rights in the Office of Justice Programs, I know it's a lot of alphabet soup, but the Office of Justice Programs is the division of the Department of Justice that hands out the dollars. They have an Office of Civil Rights, and what they have said to us is, we don't need advocates to be able to tell us exactly where the money's going in their state or even in their local jurisdiction. If you just come to us with information that the impact of fines and fees is discriminatory, and I'll be candid, it's pretty hard to find any place in the justice system where the impact of anything isn't discriminatory. We all know this. I mean, it's largely people of color or disproportionately people of color, and that pervades everything, and it gets magnified with fines and fees. So it's, if you can come to them with some information, and you'll see when we send you the information that Jeff originally sent to the department, it doesn't have to be terribly comprehensive. You just have to have some data to demonstrate what the impacts are. They will figure out whether there's enough money in the particular program that you're sending them information about or want them to look at, whether there's enough money for them to investigate. That's their job. So it's fairly easy to reach out to them. What we are happy to help anyone who's interested in putting together information to send to the department. There is a formal complaint process, but to be perfectly honest, it's really meant for individuals. The kind of things that really systemic impacts that we are looking at are frankly better addressed in a less formal manner. And I think we can make sure that they at least get the attention of people in the Office of Civil Rights. It will obviously be up to them whether they investigate. But as Jeff indicated, because the threat of losing those dollars is pretty, jurisdictions take that seriously. They don't want to lose that money. It's a lot of money that goes to states. They are likely to be nervous if they get a letter from OCR saying that they're auditing or investigating a particular practice. So I think that's really important to note. The other thing that's really important about the department's letter is that it specifically talks about one other statute, and that is the Violent Crime Control and Law Enforcement Act of 1994, which most of us don't have very positive feelings about. But in that, there are provisions that extend to police to be non-discriminatory in their policing. And the department is willing to look at police departments, at least they say so in this letter, as part of that enforcement. So that is another place where we might be able to get some traction.
Lisa, can I just add really quickly, just on one of the points you made, that with respect to discrimination, in the letter closing out the compliance review, the department said that, and I'm just again quoting here, because minority and economically disadvantaged youth are overrepresented in the county's juvenile justice system, even a consistent application of juvenile fees is disproportionate in its effect. In other words, just the fact of overrepresentation, which again, you alluded to this, is going to be true everywhere. That was enough here for them to undertake the compliance review and for the county to kind of cry uncle. So I just think that's really worth lifting up. It's not a super high, going to your point, it's not a super high bar that's been established in some other areas of civil rights litigation and enforcement.
Okay, so Priya, I'm going to turn to you because I know there's some questions that have been posed in the chat that you're ready to answer.
Yes, and I just want to also let you all know that there are also a couple of next steps from DOJ. So there is currently an open solicitation by the department, which is often a sign of what their priorities are, where they're putting their funding for a fines and fees reform project. So that is something that we haven't seen since 2015. And so that is back where they're soliciting for subject matter experts to work with state and local jurisdictions to address their fines and fees reform, and they've put funding behind it. So that's a good indicator of where their priorities are and what they want to be looking at. Also, part of the DOJ letter, it was announced that they're going to be working on and putting out a best practices guide. I think this will be one of the most useful, hopefully, once we see what's in it, tools for advocates, because this goes above and beyond, right? What does the law require, but what are the actual best practices and policies coming from the Department of Justice? So hopefully we'll have something else that we'll be able to share with you in the short term. And I'm happy to just answer a couple of questions since I'm talking and then kick it over to Tim. I know there's some for here. But one of these questions that was, what does the fact that this guidance was pulled during a Republican administration mean for how seriously states will take the guidance? I think it's a really great question, but our position is this is what we have now, and this is who we have in place now. And so the best time to be using it, advocating for it, is now, right? Where we know we have colleagues, friends, and an aligned administration on where some of these things are. And so I would not waste time, honestly, at this juncture to follow some of the recommendations here, because we do not know what it means when another administration comes into play and what they'll choose to do. And so strike while the iron is hot is probably a good reference point for this.
Let me just add one
go ahead.
point to that. And that is, even when the Dear Colleague letter came down, right, when in the Trump administration, there were some state chief justices, Ohio comes immediately to mind, that essentially sent memos out to all the judges saying, don't pay any attention to what those folks in Washington, D.C. did. As far as this court is concerned, that original Dear Colleague letter is right, and we should be abiding by it. So sometimes you can find allies in the courts that really do understand that this is basic constitutional and statutory law.
Yeah, and I think that goes to the kind of the process of how DOJ gets these letters out. They are not going to put forward a constitutional principle unless they feel that they can stand behind it constitutionally, and they have all the backing you need, even when they're extending it beyond some of the court cases to say this is the spirit of that, and we would stand behind that in litigation. And so whether or not an administration, for political reasons, pulls it down doesn't change the constitutional analysis for a lot of courts.
Priya, go ahead. I think there's.
I think, Tim, I tried to answer some of these that we could answer just by typing. So Tim, I want to give you some of these questions that require a little more dialogue.
I'll start. A question came in when we were talking about Bearden and incarceration around willfulness of non-payment. It said if the court put someone on probation for a period of their payment plan, would that be a severe restriction on liberty? I'd argue yes. Constitutionally, the Supreme Court has only dealt with it in the issue of incarceration, but the spirit of it and what DOJ, all the cases that the DOJ is citing and their reasoning would extend it to other things. Again, it's going to be an analysis of the court of what is severe enough. I would argue that, yeah, I would, this is severe enough.
And the letter actually specifically mentions this point. And if you look on page 8, and just because I forgot to say it at the outset, in the document we posted, there's brackets with a number that refers to the page in the letter where you'll find that specific point. And on page 8 of the Dear Colleague letter, they actually say, in addition, some courts have held that individuals should not be required to complete extended terms or more burdensome conditions of supervision solely because of their inability to pay. And then there's a footnote and they cite some cases. So I think you can take from that the general proposition that the Department of Justice does not think that you should be on extended probation just because you can't afford to pay, because that's imposing that kind of a condition. Let me just turn to a couple of other questions that people have posed. One was with respect to restitution. The letter does not address restitution. The department's not quite willing to go there. The only place where I know an ability to pay assessment is done when restitution is imposed is in Massachusetts, and that's pursuant to a specific Supreme Court case in Massachusetts. And I'd be happy to provide the citation to that when we send you materials, but that's the only place that I know of where courts are actually taking ability to pay into account at restitution.
Lisa, can I just add real quickly
Sure.
while you're reading the other questions? One of the things that we've started pushing for on the youth side is publicly funded restitution programs. And there's a bill in California that's still making its way through the state legislature that would do just that. So it's not a direct answer to the ability to pay question, but it's to say that a lot of the same people and communities that are on both sides of a criminal event, it's the same folks, and the current system is not serving anybody because most people who are ordered to pay restitution can't afford to do it. So most victims aren't getting anything. So it's quite broken, and so we're looking at different ways to approach that problem, including with victims advocates.
There's a question about whether it's appropriate for courts to require or to require a fee to e-file or fees for court forms. And I think the department's position is only if there is a rigorous ability to pay assessment done. That is, you can't do it if someone can't afford to pay it. If they're charging it to everybody, without having any kind of provision for people to easily demonstrate that they can't afford to pay it, and therefore, and then the fee be waived. I think in the department's view, that would be unconstitutional. Tim, do you want to answer the question about conflict of interest?
Oh yeah, I can do that one. So the question came in, Tim mentioned the conflict of interest problem for non-judicial actors, probation officers, prosecutors. Other than footnote 27, are there any useful ways to use this against prosecutors that go after high volume or low level wealth-based crimes like bogus checks, due to the ability to get a prosecutional reimbursement fee? I think the answer to that is, let's try it. You know, I think again, it's this Department of Justice is going to cite where they can, where they believe this extends to prosecutors. The question is, some of this is really new litigation, and so there may not have been tried enough. But the idea that the prosecutor is benefiting from bogus check income is a good indication that they can't be neutral in that. And so I think that these arguments under Kane and Cleese out of the Fifth Circuit can be leveraged to some way to the prosecutors. Again, it's untested ground. The Supreme Court hasn't weighed in on this yet, but I think if we use the footnotes as a roadmap and then say, oh, you know what, and it's not just us, the Department of Justice agrees with our analysis here, and quote the Dear Colleague letter, it may be persuasive in some courts.
Someone asked a question about fees that are imposed or costs not at conviction, but by outside providers. So for example, electronic monitoring fees or phone call fees, things of that sort. I think the department's position, at least with respect to fees that are imposed by some as part of the criminal legal system itself, and separate, I think, from fees that are imposed in incarceration, they are pretty clear that these provisions apply to contractors. In fact, there's specific language in the letter that says courts have an obligation to be supervising everybody. So whether it's the clerk or it's a contractor, these same principles apply. If they're an agent of the court, everything in the letter applies to them as well as to the court itself. So I think that might include some of those other private actors. The other thing is that the excessive fines clause can be applied, we think, and this is a somewhat untested area of the law, to the total amount that somebody's going to owe when they come through this, after they come through the system. So for example, if someone's convicted and part of their of what they owe at the end of the day includes electronic monitoring fees perhaps, or maybe a warrant fee or something else that occurred before they got to conviction, and that's all part of the sentence, so you can challenge that under the excessive fines clause or try.
I think we're at time, so I don't know if there's one more question you want to pull up here and lift up. And one thing I will say, just as you all look really quickly through that, is that I answered one question in the chat, but I want to make sure everyone saw it, which is we do have an ability to pay policy and guidelines that we that may help you to put together what we would consider best practices and policies around actually developing a meaningful ability to pay practice in your jurisdiction. We also partnered with an organization called Ideas 42 to translate those policies and practices in using behavioral science into forms that are actually designed with behavioral science. So are they understandable? Could a person use it and complete it themselves? And there are court orders that accompany them for how a judge would communicate what these decisions are in a court. So they are also part of advocacy packages and tools of, if that is the direction you are going to go in, is to actually try to advocate for meaningful ability to pay. What can that look like? What are those presumptions? And what does it mean to assess in the adult space a fair and reasonable fine, not fees, on an individual who comes through the court system?
And let me just answer two other questions briefly. So someone asked whether the conflict of interest provisions might apply to police. And the answer is yes. They specifically say that these apply to police and prosecutors. And the last question, which is just how do you get our help? Go to our website. And there's a contact us form. Just put in your information. Or you can reach out to any of us directly. Our email system is pretty straightforward. It's the first letter of our first names, our last names, and at finesandfeesjusticecenter.org. So we welcome anybody's requests. As Priya said, we're here to help. That's what that's why we're here. And so we hope you will reach out to us. And again, particularly if you are thinking about taking DOJ up on its interest in enforcing the principles in this letter, please reach out to us, because we continue to have a good relationship with the department right now. We think we can help make sure that they get that your complaint gets the attention that it deserves. So thank you all so much for being with us. We have recorded the webinar. It will be posted on our website. We have all of your email addresses, and we will be sending you all of the documents that we referenced. Hope you all have a great rest of your day and a good weekend.